Hey, everybody, welcome back to the Law of Self-Defense show. Make yourselves comfortable. Come on in. Come on in. Welcome, welcome, welcome. I am, of course, Attorney Andrew Branker for Law of Self-Defense. Thank you. Thank you very much. And today we're going to talk about a young woman who was convicted of murder and recently just this week, got her conviction reversed and remanded for a new trial. We'll have to see whether or not a new trial actually happens. Because, of course, as the first trial, it's really up to the discretion of the prosecutor whether or not the trial happens. And in these cases where a conviction is reversed, it's usually because there was some legal error in the first trial, and the prosecutor has to consider whether he can win in a second trial with that legal error corrected. Because the idea is the legal error in the first trial is what enabled the conviction in the first place. That's what makes the conviction wrong. If the legal error happened but didn't make a difference to the conviction, if the defendant would have been convicted anyway, then it's a harmless error. It's not grounds for reversal of a conviction. There's a lot of interesting legal issues in this particular case, and we're covering it because we have the appellate court decision reversing the conviction. So we have their reasoning. It's a case that involves the defendant here was a young woman who was purportedly subject to pretty extreme domestic abuse. So we have that emotional dynamic to it. We have battered spouse syndrome, arguments to be made here. We have the court, interestingly enough, appears to be viewing the evidence not in the light most favorable to the state, the light most consistent with conviction, which is what the court's supposed to do. Once a conviction happens, the presumption is that you are guilty, as the jury decided. When the court goes over the facts of this case here, it looks to me like they're really viewing them in the light most favorable to the defendant, to the appellant, to the woman who was convicted, which is not the norm, but it does happen in these domestic abuse kinds of cases because of the obvious sympathies involved. And there's a number of other interesting legal issues that have to do with this case as well. Before I jump into that, let me get the housekeeping out of the way as people filter in. Of course, we have our sponsor, which is none other than the Law of Self-Defense itself. We have our Law of Self-Defense Advanced course coming up fast, folks. It's only about a couple weeks away now. Saturday, April 15th. This is our full-day class taught live by me, streamed to you at your computer, that teaches you how to be hard to convict if you're ever compelled to defend your family, yourself, your property. And if you sign up for this class this month, today's the last day of the month, folks. So today is the last day to get the 10% discount off the course registration. The URL to register is lawofselfdefense.com/advanced, but I would encourage you to go there even if you're not sure yet, because we have a lengthier video there explaining the more than 100 very specific use of force questions we answer over the course of the class, and it gives you a very robust understanding of just what you can expect from spending the day with yours truly in our Law of Self-Defense Advanced class. Again, that's at lawofselfdefense.com/advanced. I should also mention we still have our law cards available for those of you who might be interested in that. I have a new image and I forgot to pull it up. So let me take care of that. Well, I thought I had a new image. Let's see. It's not that folder. It's this one. Here we go. That's the one I wanted. So these are baseball card-like affairs put together by Farmhand Tom, one of the fans of the Law Tubers. It features all the Law Tubers you know and love. Here's a picture of Nick and I and Steve Gosney in Vegas a couple weeks ago. They have a series of cards that are just Branca Burns, is what they call them. And you can learn more about all of this at lawselfdefense.com/law cards. I don't sell the cards. That'll just redirect you to the Kickstarter where the cards are available, and you can see all the variations that are being offered. There are only 10 hours left, folks. So this is, of course, a gag gift. I mean, only look at it if you're interested, but I thought they were pretty funny. Myself, I know Nick is shares that opinion. So does Steve. We're all very encouraging of Farmhand Tom and grateful to him for putting this together. Certainly, I'll be collecting a set. I'll probably frame a set, hang them in my office. That's how funny I think they are. But there's only 10 hours left. So if these are at all of interest, lawofselfdefense.com/law cards. And not that decision. Let's see. What did I do with the court decision I wanted to cover today? Hold on a moment. It was right here a moment ago. This woman who got her conviction overturned. And here it is. Okay, this is a Minnesota case. And really the core, most interesting issue in this case has to do with the element of imminence. Of course, imminence is one of the 5 elements of a claim of self-defense. Hopefully you all have our little law self-defense elements cheat sheet by now. We make this available for free. It lists the 5 elements of self-defense, the 5 building blocks of any claim of self-defense, the 5 targets for attack for a prosecutor if you're claiming self-defense, provides a brief description of each. We make this available for free. Don't charge a penny for it. It's just a PDF download at lawofselfdefense.com/elements. And those 5 elements are, of course, innocence, imminence, proportionality, avoidance, and reasonableness. And the key element here, now this woman was being abused and she shot and killed her claimed abuser, but under circumstances in which traditional imminence did not appear to be present. That was the target of attack for the prosecution on this woman's claim of self-defense. And imminence has to do with the requirement, and I'll provide the normal definition of imminence here, and then we'll explore how it's really a variation of imminence, almost specific to domestic abuse cases, that applies here, that this court recognized. So imminence normally requires that the threat you're defending yourself against either be actually occurring, so the beat down is happening, shots are being fired at you, or it's immediately about to occur. So the fist is pulled back, the person's reaching to present the gun, it's about to happen. It's not some past threat that's unresolved, and it's not some speculative future threat that may never happen. So you can think of imminence in most cases, 99% of cases, as a kind of a window. So when there's no threats, or there's only a speculative future threat that may never happen, the window of imminence is closed, and you don't have imminence. If you don't have imminence, that's a required element of self-defense. You don't have self-defense as a justification for your use of force. Then the window of imminence opens. The threat has become imminent. It's either actually occurring or immediately about to occur. You have the element of imminence. If you also have the other required elements of self-defense, you have a legal privilege to use force in self-defense. But of course, imminence doesn't last forever. It ends. The window closes. The threat's over. And once the threat is over, once the element of imminence is no longer present, you've lost the element of imminence. You've lost self-defense as a legal privilege to use defensive force. That's the traditional definition of imminence. Now, there is, it's almost largely legally theoretical. It's the kind of thing you would find in a textbook, for example, to stretch a student's mind. But it's an understanding of imminence that's different than what I just described. It's an understanding of imminence that includes what I just described, the threats either occurring or immediately about to occur, but it can also include threats that are otherwise unavoidable. They're not happening in the moment. They're not immediately about to happen, but they will certainly happen eventually. At least you have a reasonable expectation they will certainly happen eventually, and you have no other means of avoiding that future apparition of imminence except to use force right now. And the law school textbook illustration of this might involve kind of a kidnapping scheme where someone's been kidnapped, they've been chained to a radiator in the basement, and their kidnapper, being a psycho, has this weird belief that he can't kill his victim on the day of the kidnapping. He has to wait a week. But on the 7th day, he kills his victim. And he tells the kidnapped victim this, and the victim believes him. On the 7th day, he's dead. And he's handcuffed to a radiator. He can't just walk out, can't leave, can't call for help. But every morning, the kidnapper brings breakfast and lunch and dinner, lays a little tray in front of the kidnapped victim. And the kidnapped victim realizes, you know what? If I can grab this guy, kill him, I can get the key to this handcuff and I can escape. Now, on day 1 and day 2 and day 3 and day 4 and day 5 and day 6, arguably, there's not an imminent threat of death to the victim, if we believe the hypothetical, right? The threat of death doesn't happen until the 7th day. On days 1 through 6, there's a future threat, but it's not an imminent threat under the classic definition of actually occurring or immediately about to occur. But because of the circumstances, the threat is otherwise unavoidable. On the 7th day, it's going to happen. Under that hypothetical, do you have to wait to the 7th day before you can use deadly force to defend yourself? No. Nope. You don't have to wait, because it's the only way to use force earlier is to prevent that otherwise unavoidable threat of death from happening. So that's the law school textbook illustration of this alternative, obviously rare, definition of imminence for use of force law purposes. Much more commonly, however, this expanded notion of imminence, that it's not stopping a traditionally imminent threat occurring or immediately about to occur, but the force is being used to stop an otherwise unavoidable future threat of harm. It often occurs, or it's argued, in domestic abuse situations, where the circumstances are such that a reasonable and prudent person in the same circumstances as the abuse victim would believe that they are facing an otherwise unavoidable threat of deadly harm, much as if they were chained to a radiator. Now, you might say, well, but she's not chained to a radiator. She can just leave. I'm presuming the victim is a she. Often it's a she. It's a lot more men are abused statistically than you could possibly imagine if you haven't looked at the figures yourself. But the defendant here is a she, so I'll just use the pronoun she. You could say, well, she's not chained to a radiator. She could just walk out the door. It is otherwise unavoidable, this threat. But the psychologists have argued, and the defense bar has argued, and the courts in every state now have accepted that there are traumas that occur in the course of domestic abuse that often leave the victim believing that they can't simply leave, or if they leave, it would be pointless. The guy will go and get her back. In this particular case, the woman is living with her abuser, and she has a 5-year-old child in the home as well. So she can't just leave without the child. Maybe if she tried to leave with the child, that would be sufficiently cumbersome that the abuser would prevent her, whatever the case might be. So that's the idea of this expanded definition of imminence. So the key question here for this appellate court decision was that broader definition of imminence applied by the trial court in this particular case to this woman's circumstances. Now, Minnesota had no existing law on this. So Minnesota, at the time of this woman's trial, only had the narrow definition of imminence, that you could only be privileged in using deadly force if the threat you were defending against was traditionally imminent, actually occurring or immediately about to occur. And as we go through the facts of this case as recounted by the appellate court, we'll see that that wasn't the case. She had been subject to abuse. More abuse was promised, but in the moment she defended herself she used deadly defensive force in purported self-defense. In that moment, she was not facing a traditionally imminent threat of deadly force harm herself. So normally, in the normal traditional analysis, that would mean she didn't have the element of imminence, and therefore she couldn't have self-defense. So what this appellate court decision is doing, in essence, is holding that Now, as a matter of case law, court-made law, Minnesota defendants arguing in these kinds of circumstances are privileged to have the jury instructed that they can consider not only the narrow definition of imminence, but also this broader and otherwise unavoidable harm definition of imminence. All right, so that's the broader legal view of this case. Now, let's take the opportunity to actually step through this opinion. I always like reading case law opinions because that's where the rubber hits the road, folks. Remember, statutes by themselves are just words on a piece of paper. They don't have any effect in the real world, standing alone. Statutes don't have an effect in the real world until they're interpreted and applied by courts to real people in real cases. And often the courts will supplement statutory law with their own court-created law, with case law. And we see that happening here. There's no statute that changes the scope of imminence here. It's solely the appellate court. Right. So at this point, I should ask everyone to please hit that subscribe button. Thank you. We're at 48.3 thousand subscribers. Be great to hit 50. If you like the content, then I don't know why you're here. If you don't like the content, hit that thumbs up button. We got 175 people watching, only 60 likes, folks. Come on, a third of you. Let's get with it. If you could leave a comment, even if it's only your city and state, that would be greatly appreciated. And we should be streaming on YouTube, on, let's see, Twitter. Is Twitter working? Come on, Twitter. I don't know. Twitter. It is. And on, let's see. Is Rumble working? Yes. Okay, so we're streaming on our four major platforms: YouTube, Rumble, Twitter, and our Law Self-Defense membership. Of course, if at the end of all this, you'd like to have your questions answered by me personally during the show, there's really three ways to do that. One, if you're watching on YouTube, is this a $5 minimum YouTube Super Chat. If you're on Rumble, a $5 minimum Rumble rant. Or if you're a Law Self-Defense member, just put your question in the member chat. Please preface it with question in all capital letters so I can pick it out from the background chatter. And those are free. That's just part of your Law Self-Defense membership. By the way, folks, instead of paying $5 a question on YouTube and Rumble, you could be a Law Self-Defense member for less than $10 a month, 30 cents a day, and get all your questions answered for free. So if that's of interest, you can join right now instantly, become a member, get instructions on how to access your member dashboard and watch this show and all our other live streams live in the member dashboard and get all your questions answered for free. You can do that at lawofselfdefense.com/join. All right. So the decision, State of Minnesota versus Stephanie Clark. Where is my, here we go. Filed March 27th, 2023, which I believe was just this past Monday, no? It sure was. So this is a brand spanking new decision. We have here the, of course, as usual, I'll just go through kind of the portions of an appellate court decision here. We have the parties involved, State of Minnesota versus Stephanie Louise Clark, the defendant at trial, but once convicted and appealing, she becomes the appellant. When it's filed, the outcome, spoiler, of this decision reversed the trial court conviction. The case file number, this would be for every criminal prosecution. Every civil case would also have one. Normally, then it would read CV instead of CR, kind of a license plate number for this particular case. The lawyers involved for the state and for the defense, and the judges who played a role in this hearing. And of course, in the appellate courts, most states for serious offenses have basically three levels of courts: the trial courts, the mid-level appellate courts, and their state Supreme Court. And the mid-level appellate courts are typically 3-judge panels, and the state Supreme Court is some larger odd number, 7, 9. The mid-level appellate courts, they're put together by it's supposed to be a randomized collection or selection of 3 mid-level appellate court judges from a larger pool. So the 3 judges on any panel for a mid-level appellate decision change from time to time, from case to case. And these are just the three we have here: Reyes, Larson, and Klopp-Hack, who I think actually wrote the decision. Yes. Now, it says here, this is interesting too, it says here non-precedential decision opinion. Why would it be non-precedential? I mean, it has presidential authority over other courts. This is just an administrative note they put on these decisions. When there's a large enough body of appellate court decisions, the appellate courts, because lawyers will be citing to all these appellate court decisions as case law. But if, say, there's 10,000 of these, well, the court doesn't want to have to know 10,000 citations, what the key holding of each of those was. So a lot of new ones, they'll mark down, if they're redundant, they'll mark them down as non-precedential. So don't cite this one. Cite the preferred case on that particular issue as precedential authority. It's just a convenience for the appellate courts. So here, appellant, this would be the woman Clark, argues that her conviction for second-degree murder must be reversed because, one, the district court's supplemental jury instructions materially misstated the law of self-defense. The district court abused its discretion in the admission of witness testimony, and the district court abused its discretion by preventing appellant from presenting evidence relevant to her departure request at sentencing. Departure request means that she would normally be sentenced to some range of time, and she was looking for a non-standard sentence, something lesser than the normal range. That would be the departure from the normal sentencing schedule. We only cover number one in this decision because once this appellate court made its decision on the first of these claimed errors, there was no need to consider the other errors. It continues, we determined the district court materially misstated the law of self-defense by defining imminent as immediately. That's the traditional narrow definition of imminence. By failing to tailor the instruction to the unique circumstances of the case, and therefore we reverse on this basis. Based on this determination, we do not reach the remaining issues 2 and 3 here. So a couple of interesting things here is the trial court didn't really make an error. The trial court instructed the jury according to existing Minnesota law, which only allowed for this narrow definition of imminence. So the trial court didn't do anything wrong. What happened is after this was appealed and this appellate court got this case, they decided they wanted to expand the definition of imminence beyond merely immediate. They changed the definition of imminence. And now they're sending it back to the trial court and saying basically, well, it's not that you did the wrong thing. You applied the narrow definition, which was the law, but now we want you to do it again with the broader definition of imminence. Something else worth noting here, of course, as they reversed her conviction. So she's going back for a new trial, or maybe there won't be a new trial. Who knows? But for everyone out there who says, well, the person got convicted, the defendant got convicted, therefore that's locked and that's it. They're guilty. There's no question about it. Folks, no. And of course, this happens with like the Alec Murdaugh trial, right? He got convicted. And now all the anti-Murdaugh people are like, well, that's it. We were right all along. We were right. He got convicted. That settles everything. But of course, even a conviction in trial is not a final adjudication of guilt because you can appeal. And sometimes when you appeal, you get your conviction reversed. So you're not guilty, at least not yet. Right? If the jury verdict were the final adjudication of guilt, we wouldn't need appellate courts. But trial courts make mistakes. Juries make mistakes. Sometimes the guilty verdict is unjust, is contrary to the legal merit. And that's what we have appellate courts for, is to do what they're doing here and reverse that conviction. All right, let's look at how this court represents the facts. So an interesting thing about the facts here, the representation by the appellate court, is normally once you're convicted, so at your trial, the facts were being argued in two variations, right? The jury was being told two different stories built out of the evidence in the case. One is a story of guilt told by the prosecution. One is a story of not guilt told by the defense. And the jury has to decide which story they believe. Well, if they come back with a guilty verdict, it's presumed that they don't tell us, of course. The jury doesn't explain how they arrive at a verdict, but it's presumed that if the jury returns a guilty verdict, that the version, the story, the narrative they believed was the narrative consistent with guilt, that the facts that the jury believed proved were the facts as presented by the state, by the prosecution. And typically, the appellate courts, they don't like to reverse on the facts of a case because they don't hear witnesses. They don't see testimony, hear testimony, see evidence being presented like a trial court does. The appellate courts only basically get transcripts and then arguments from the appealing parties. The appellate courts typically reverse on the basis of some claimed legal error. And they do that here. But before they get to the legal error, the appellate court here provides its version of the facts. And normally the appellate court will say, well, these are the facts in the light most favorable to the state, because it's presumed that the state's version was the version accepted by the jury. And that's what's locked in moving forward. What's interesting here is that this appellate court will see as they present the facts that their presentation of the facts is extremely favorable to the appellant. They don't say they're doing this, but it sure looks like the appellate court has decided to view the evidence in the light most favorable to the appellant rather than most favorable to the state, which is the norm. And I'm sure that's a result of the appellate court sympathy for the appellant here as a claimed abuse victim. All right, so the facts. In 2020, appellant Stephanie Louis Clark was in a romantic relationship with DB. Clark, the appellant here, her 5-year-old son, and DB lived in Clark's home. So it's her house. This dude's just living there. DB became abusive toward Clark approximately a month and a half after he moved into her house. This abuse became progressively worse over time, and by January 2020, occurred nearly every day. DB prevented Clark from socializing with her friends or family and did not permit her to leave the home without permission. DB also yelled at, pushed, kicked, and slapped Clark. So far, folks, where would this information come from? It almost certainly came from the appellant herself. These are her claims of fact. And the boyfriend or whatever, he's dead. So we're not hearing his side at all. If someone wanted to fabricate a history of abuse, they could just say these things, right? We don't really know whether or not these things are true, but the appellate court here is certainly accepting them as if they were true. It's unquestioned. Continuing, when DB became angry with Clark, he forced her to kneel in a kneeling spot in front of a door and hit her in the head if she did not comply. On at least one occasion, DB held a loaded firearm to Clark's head. DB kept several firearms around the home and frequently paced around the home with a firearm. Now, if someone's holding a loaded firearm to your head, is that an imminent threat of deadly force harm? Of course. Did this appellant shoot DB when he was holding a gun to her head? No. That's the difficulty here if we restrict ourselves to the narrow definition of imminence. On March 5th, 2020, note that date, folks, March 5th, 2020, DB and Clark got into an argument. DB forced Clark to kneel in her kneeling spot and punched her with a closed fist. DB's violence continued to escalate that evening as he held a loaded firearm to Clark's head. Clark later left the home to pick up her son. And some people would say, well, that's a good opportunity to flee, right? But this is where the whole psychology of abuse spouse syndrome comes into play for the courts. After Clark returned home, DB continued hitting her, punched her with a closed fist, and hit her in the face with a basketball. DB threatened Clark by saying, wait for tonight. Wait for your son to go to bed. I'm going to break your ribs. Who would we have heard this evidence from? From the appellant, right? It's the only source. Clark was afraid DB was going to beat her to death. So we have a threat here of future harm. Is this an imminent threat in the moment? No, it's a future speculative threat that may or may not ever happen. And the traditional Supreme Court definition of imminence includes things like being unable to call for the assistance of others. Does the appellant here, did she have at the time the option to call for the assistance of others in a practical sense, if not in a psychological sense? Sure, of course. So here, the traditional narrow definition of imminence would not apply. Clark testified, I remember feeling terrified. I remember feeling like I wasn't going to wake up. I remember being scared for my son. At that point, she picked up a nearby firearm and shot DB. DB went into the bedroom where Clark picked up a second gun and shot him again. DB died of multiple gunshot wounds. All right, remember, this all happened on March 5th, 2020. On March 6th, 2020, 1 day later, folks, the state of Minnesota charged Clark with second-degree intentional murder in violation of the Minnesota's murder statute. That's quick, folks. Was there any substantive investigation here at all? Within 24 hours, they had a charge with second-degree intentional murder? Pretty darn quick. Following the trial, the jury found Clark guilty of the offense, and the district court imposed a 306-month prison sentence. So something a little bit under, well, it's a long prison sentence, right? Let's see. Clark now appeals. So appellate courts, when they're being kind, they front load their ultimate finding, their ultimate legal conclusion to save everybody time, and they do that here. Decision. The district court erred in its jury instructions because it materially misstated the law of self-defense. I would suggest that's not the case. I think the trial court stated the existing law of self-defense just fine. They just couldn't see into the future and know the appellate court was going to change the definition of imminence. But in any case, because it materially misstated the law of self-defense and failed to tailor the instructions to the unique facts of this case. Clark challenges the district court's definition of imminence in response to the jury's question to define the term as found in the jury instruction describing Minnesota's self-defense law. And then they go over a bunch of words here that basically say that the jury needs to be properly instructed on the law, that the district court has latitude to customize the jury selections for the facts and issues in the case. The trial court should avoid jury instructions that cause confusion or materially misstate the law. An appellate court, like this court here, reviews jury instructions as a whole to determine whether they accurately reflect the law. And folks, correct jury instructions are a key facet of due process. So everybody is entitled to correct jury instructions, and the appellate courts are very sensitive anytime the jury instructions can be presented as having been defective. The court says, we review jury instructions for an abuse of discretion, and a court abuses its discretion when its instructions erroneously state the law. Now, again, I don't think the trial court did that. I mean, the trial court just read the standard jury instructions, but the standard jury instructions had the narrow definition of imminence, and this appellate court prefers the broader definition. In response to a question from the jury, the district court may give additional instructions, and that happened here. Clark argued at trial that she acted in self-defense when she shot DB because she feared he would kill her or hurt her son. The trouble, of course, is that under the traditional definition of imminence, the feared harm would need to be actually occurring or immediately about to occur, which was not the case here. The feared harm here was a prospective, arguably speculative threat. Continuing, an individual may act in self-defense if she reasonably believes that force is necessary and uses only the level of force reasonably necessary to prevent the bodily harm feared. A defendant bears the burden of producing evidence to support a self-defense claim. This is what's called, folks, the burden of production. You don't have an automatic right to argue self-defense at trial. There has to be some evidence on each of the 5 elements to support a claim of self-defense, because if there's zero evidence for one of the required elements, well, then the element can't be found to be proven by a jury. All a jury does is consider evidence, right? They're the finder of fact. If there's zero evidence to consider on an issue, the issue doesn't exist. Zero evidence on an element, the element doesn't exist. So there has to be more than zero evidence to support each of the required elements of self-defense before you're privileged to argue self-defense at trial. Now, the good news is you don't need a lot of evidence. You basically need more than zero evidence. So it's a very low threshold, but you do have to meet it. And that's this burden of producing evidence to support self-defense. Once the defendant meets that burden, then the burden shifts to the state to disprove one or more of the self-defense elements beyond a reasonable doubt. So each of the required elements now becomes a target of attack for the prosecution. If they can disprove any one of them, the entire claim of self-defense collapses. And that's a problem, right? Because when you argue self-defense, you're not saying it wasn't me. I didn't shoot that guy. I was someplace else. You're arguing it was me. I shot him, but I did it in lawful self-defense. Well, if the self-defense collapses, what's left of that statement except for a confession? Okay, so Minnesota law permits the use of reasonable force against another when used by any person resisting or aiding another to resist an offense against the person. Deadly force may be used when necessary to resist or prevent an offense which the actor reasonably believes exposes the actor or another to great bodily harm or death. The Minnesota Supreme Court has articulated the following four-part test when interpreting the self-defense statute. And again, folks, it's actually 5 elements when avoidance, when retreat is required, and Minnesota is a duty to retreat state. It's not 4 elements, it's 5. When the court says 4, when you look closely, what you'll invariably find is that they've conflated 2 of the elements into 1. That's just sloppy legal thinking, but it happens all the time. So, for example, here, first element, the absence of aggression or provocation on the part of the defender. That's the element of innocence, right? You can't have been the initial aggressor in the confrontation. You lose the element of innocence if that's the case, and then you lose self-defense. What this court calls the second of 4 elements, the defendant's actual and honest belief that he or she was in imminent danger of death or great bodily harm. Well, this is actually conflating 3 of my elements into 1. The actual and honest belief is subjective reasonableness, the subjective half of reasonableness. The other half is objective reasonableness. The imminent danger is imminence, my element of imminence, and death or great bodily harm is my element of proportionality, the intensity of the force involved, non-deadly force or deadly force. Element 3 here is the existence of reasonable grounds for that subjective belief. So this would be objective reasonableness, the other half of the reasonableness element in my paradigm. And finally, the absence of a reasonable possibility of retreat to avoid the danger. That's the element of avoidance, which most states, only 11 states, still impose in otherwise lawful cases of self-defense, but Minnesota is one of them. So in Minnesota, we really have to deal with all 5 elements. Now, you might argue that she defended herself, in theory, against her abuser in her castle. So shouldn't castle doctrine take away the element of avoidance? The problem is, and I didn't look at Minnesota law closely on this to refresh my recollection, but in many states, castle doctrine only applies to intruders, people not lawfully present. It doesn't apply if the other person you're using force against, if it's also their castle. Then both of you have castle doctrine privileges, and in effect, some of those jurisdictions will reimpose the legal duty to retreat if you're defending yourself against a co-dweller, as here. So this form of self-defense is referred to as the justifiable taking of life. It's a perfect defense, folks. It means it simply was not a crime. The killing was not a crime at all. Continuing, in the final instructions, the district court instructed the jury on the law of self-defense, which was consistent with the jury instructions guide. So this is important. Every state, in the old days, lawyers used to draft jury instructions fresh for every trial. And then the state would draft its desired version of the jury instructions. The defense would draft theirs. And then the court would either adopt one or the other or kind of put them together, mesh them together, however the court thought best. But when you do this kind of customized jury instruction process, you get a lot of variation on a case-by-case basis. And the courts didn't like that. So it's been common practice for many years now that the Supreme Court in each state will put together panels of experts to come up with a standardized set of jury instructions that every court is supposed to use. And if a trial court varies from those standard jury instructions, that's one of the most common ways they get reversed on appeal, because the appellate courts told you how they want it done and you did it a different way. So here, the appellate court is telling us, well, the trial court gave the jury instruction on self-defense consistent with the standard jury instructions, which is what the trial court is supposed to do. They get spanked when they don't do that. Here they're getting spanked even though they did that, because this appellate court wants to expand the definition of imminence. So the district court, that's the trial court, stated to the jury, instructed the jury, quote, "The defendant asserts the defense of the justifiable taking of life. No crime is committed when a person intentionally takes the life of another if the person's actions was taken in resisting or preventing an offense of a physical nature the person reasonably believed exposed her to death or great bodily harm. The defendant may use all force and means she reasonably believes necessary and that would appear to a reasonable person in similar circumstances to be necessary to prevent death or great bodily harm that appears to be imminent." That's the key word for this decision, imminent. "The kind of degree of force a person may lawfully use in self-defense is limited by what a reasonable person in the same situation would believe to be necessary. Any use of force beyond that is unreasonable." Close quote. Now, just in passing, folks, this decision is really about the element of imminence. But look how often the element of reasonableness is referenced in these jury instructions. It's everywhere. And that really reflects the weight and importance that the law of self-defense puts on this element of reasonableness. That's why I call it essentially an umbrella element that hangs over all the other elements. Everything that you perceive, you decide that you do in self-defense has to be both subjectively and objectively reasonable. And the trick is, the danger is that it's not actually your determination of what's reasonable that controls your legal fate. It's what other people think was reasonable or not. It's what the police think, what the judge thinks, what the prosecutor thinks, what the jury thinks. If you believe what you did was reasonable, but the jury thinks it was unreasonable, guess what your legal fate is? It's determined by the jury's perception of reasonable. So it's a very rich target of attack, vulnerable target of attack by a prosecutor. So continuing now with the decision. During deliberations, the jury sent a note to the trial court asking, what is the legal definition of the term imminent? Well, after conferring with counsel and over the defendant's objection, the district court instructed, because the defense knew this was a big problem, right? Because the defense knew that the traditional definition, the narrow definition of imminence would not work here, because their client was not facing a traditionally imminent threat when she shot the victim, the abusive boyfriend here. So, of course, the defense objected to the narrow definition of imminence. The trial court instructed the jury that to fear imminent great bodily harm or death means that the person must fear that such harm will occur immediately. Right? That's the traditional definition of imminence. It's either the attack is in progress or it's immediately about to occur. The trial court agreed that with the state's recommendation and based its reasoning on the model jury instructions for criminal sexual conduct offenses, which provides that to fear imminent great bodily harm means that the person must fear that such harm will occur immediately. So this is always a danger, folks. So they couldn't find a good definition of imminence in the state's use of force law. So instead, they looked at the criminal sex offenses area of the law, found the definition of imminence there, this narrow definition, and imported it for use in a use of force case. You can do that. There's nothing inherently wrong with doing that. The danger is every time you take a legal term of art from one context and try to apply it in a different context, it may not work. Because often the policy reasons why a legal term of art has a particular definition in one context doesn't readily apply in the other context. Some of you may remember I had a disagreement back in the Kim Potter case. Kim Potter thought she was tasing the Dante Wright, the driver of a vehicle, and she unintentionally pulled her service pistol and shot him fatally. And an argument was being made by Natalie. You'll remember Natalie. Thanks for the car, Natalie, and the watches. I appreciate it. An argument was made by Natalie that DWI law says that Natalie was trying to argue that even the use of the taser would have been unlawful by Kim Potter because you're not supposed to tase people who are operating a vehicle. Okay, why not? What's the public policy against that? Well, if someone's actually, the car's in gear, their foot's on the gas, and you tase them and their foot hits the gas, now you have an unguided, immobilized driver behind the wheel and an unguided missile flying down the street. It could kill any pedestrian. It could crash into another car, go through a house. Who knows? So you don't want to create that kind of danger to others. So you're not supposed to tase people who are operating a vehicle. In this case, the evidence was that the vehicle was in gear. So it couldn't be moved if someone simply got shocked and stepped on the gas. The engine would rev, but the car wouldn't go anywhere. And Natalie was arguing, well, DWI law says you're operating the car if basically you're doing anything with it. I mean, if you're sitting in the car and you turn on the radio, you're operating the vehicle. You put the key in, don't turn the car on, you're operating the vehicle. And she was arguing that because that was the definition of operating a vehicle for DWI law, that should be the same definition applied in the context of Kim Potter's intending to use a taser, and Dante Wright, that the use of the taser would be unlawful because you're not supposed to tase someone who's operating a vehicle. But it doesn't work, that legal argument, because the public policy reasons for why you would define operating a vehicle in a particular way are different for DWI law than for use of force law. For use of force law, the concern is that you'll instantly have a missile going down the street. Well, the car's in gear. That's not going to happen. So there's no reason not to tase someone who's in a car, even if the car is running, if the car is in gear. For DWI law, it does make sense if we accept that the first step of a drunk person operating a vehicle is to put the key in. They're not putting the key in so they can leave the vehicle and walk home. They're putting the key in presumptively because they're about to start the car and start moving it down the roadway, and we don't want drunk people driving down the roadway. So it just doesn't make any sense to take the DWI definition of operating a vehicle and try to fit it, that round peg into the square hole of why, under what circumstances you might not want to tase someone for use of force law purposes. Well, we have the same risk here, that you're taking the narrow definition of imminence from sexual assault law and attempting to apply it in use of force law. You have to think to yourself, well, are the underlying policy principles the same? Because if they're not, you may again be trying to put a round peg of an argument into a square hole. Let's see. After providing its instruction on the definition of the term imminent, the district court excused the jury to continue deliberating, and shortly thereafter, the jury found Clark guilty of second-degree murder. Well, they would have to, right? A reasonable jury would have to, because if you're only allowed to apply the narrow definition of imminent, meaning the threat was occurring or immediately about to occur, that just doesn't apply to the facts of this case. If you don't have the element of imminence, you don't have self-defense. If you don't have self-defense, she conceded she shot him. And if there's no self-defense justification, it's just an easy conviction. So the court continues. We are persuaded that the trial court materially misstated the law because it incorrectly instructed the jury that imminent means that such harm will occur immediately. There is no legal basis for this erroneous instruction. When instructing on self-defense, courts must use analytic precision. I certainly agree with that. This is part of my disagreement with people who engage in emotional legal analysis of use of force cases. That just muddies the water, folks. That doesn't lead to good legal analysis. You have to approach legal analysis, well, as an analyst, from an analytic perspective, emotion-free. Case law does not define the term imminent in the context of the law of self-defense as it is raised in this context. The trial court relied on another decision, Boyce. That would be an appellate court decision that's being used here for precedent, which states, quote, the justification or excuse which exonerates a defendant from all criminal responsibility depends not on the state of his emotions at the time of the killing, but rather on the quality of his judgment with respect to the danger to be apprehended from others and the alternative methods by which the danger could have been avoided, like retreat, for example. Acts sufficient to incite a passion in a person having ordinary control over his emotions would not necessarily cause such a man to consider himself in danger of death or grievous bodily harm, or cause a reasonable person to think it necessary to kill in order to preserve himself. So really they're talking here about the fact that you need that element of reasonableness has both a subjective component. You need a genuine good faith belief that you need to kill to save yourself, and an objective reasonableness component, that belief, that subjective belief, can't be an irrational belief. It has to be reasonable. A hypothetical, reasonable and prudent person would have shared that subjective belief. The appellate court continues, upon review, we determine the trial court misread Boyce. The trial court's jury instruction seemingly conflated the elements of heat of passion manslaughter with the justifiable taking of life defense. So you can have murder, the intentional killing of another person. You can have self-defense, which is not a crime at all. Or you might have what's called imperfect self-defense, where someone defends themselves irrationally. They don't have an objectively reasonable argument for self-defense. And sometimes what happens then is the courts will, it's called imperfect self-defense. It can't lead to an acquittal because you don't have perfect self-defense, but it can mitigate murder down to manslaughter. That's what they're referencing here. Continuing, the trial court's supplemental instruction relied on the definition of heat of passion. That would be another way to mitigate from murder to manslaughter, and the emotion required to reduce murder to manslaughter, as opposed to whether an actor reasonably believes that deadly force is necessary. The Minnesota Supreme Court, so that's the court that's over everything, right, including this appellate court, and all the trial courts. The Minnesota Supreme Court instructs that a trial court must consider the individual facts of each case to determine whether the situation is one in which the ordinary reasonable person would consider killing necessary to avert the danger of death or grievous bodily harm. So I referred to this as the customization of the objective reasonableness requirement. So the idea there is that in a hypothetical, objective and reasonable person would have shared the subjective fear, but we can customize that objective person for the circumstances of the situation. Was it daytime or nighttime? Was it a hectic environment or a calm environment? Were you inside your house, outside your house, that kind of circumstances, customization, and for the any special abilities or disabilities of the defendant. Did the defendant have one leg? Did the defendant have fighting expertise? That kind of thing. Was the defendant unusually vulnerable to harm? Were they small, weak, on blood thinners? That's can all be customized into the reasonable person standard. And a variety of other things. So they're referring here to that customization of the objective reasonableness component of reasonableness, one of the 5 elements of self-defense. Continuing, this analysis turns on the character of the danger to be apprehended and the available alternatives rather than on the defendant's emotional, subjective reaction to the situation. As stated, the trial court's instruction focused on Clark's emotional reaction and relied on heat of passion discussion on Boyce rather than on the justifiable taking of life analysis. The correct analysis included a temporal component guided by the unique facts of each case. That temporal component, folks, is what we've been discussing when we talk about imminence. The traditional definition of imminence, the threats actually occurring or immediately about to occur. The broader definition of imminence is a threat that's otherwise unavoidable. That's pushing out the time, the temporal boundary of things that would still qualify as an imminent threat. As discussed above, the facts of the case are tragic. The trial court should have followed the Supreme Court's admonition to tailor the jury instructions to these facts, particularly in light of the victim's escalating and violent abuse against Clark. Again, this is the appellate court viewing the evidence in the light most favorable to the person convicted, rather than most favorable to the state, which is not the norm. Rather than making a blanket statement that imminent means immediate, the law requires a more nuanced instruction based on the unique facts of each case. The Minnesota Supreme Court has not defined the term imminent in the law of self-defense. So how would the trial court know to use some expanded definition of imminence? And it is for the Supreme Court, rather than the trial court or this court, the mid-level appellate court, to define this term. We find decisions from other states persuasive. So here we have a Minnesota mid-level appellate court deciding to look at other states' laws for guidance. Is the other state's law binding on a court in Minnesota? No. But do courts, when they can't find what they want in their own state's law, can they go fishing in other states' law and say, well, that seems convincing to us, so we're going to adopt that approach? Sure, and that's what they're doing here. We find decisions from other states persuasive, however, and we may look outside Minnesota when our own jurisprudence, when our own law is undefined. We are impressed by the Kansas Supreme Court's recognition of the unique nature of domestic abuse as it relates to a claim of self-defense. The Kansas Supreme Court determined that the use of the term immediate instead of imminent in the jury instructions was reversible error. The court explained that the use of the word immediate places undue emphasis on the immediate action of the deceased and obliterates the nature of the buildup of terror and fear which has been systematically created over a long period of time. So you can see how they're taking in the psychological trauma of domestic abuse as they see it as a rationale for expanding the boundaries of imminence beyond the traditional scope of immediate. This court continues, we find this analysis presented in these cases to be persuasive. Our own law is undefined as to the precise definition of imminent, and in the absence of a defined term, the district court should have tailored its instructions to the particular facts of this case. The elements of self-defense are by nature very specific to the person apprehending fear and the very particular circumstances causing fear. Instead, the trial court engrafted a requirement onto the term imminent that does not exist in our case law. Folks, I can assure you that Minnesota trial courts have been using the narrow definition of imminence forever. Forever. There's been thousands and thousands of self-defense cases in Minnesota history where the narrow definition of imminence is just used. That's the norm. Given DB's violent actions against Clark, the jury could have found that Clark was in imminent danger of great bodily harm, even if such danger was not immediate. Meaning is, this court doesn't use this phrase, but what I would describe as otherwise unavoidable. It's inevitable, even if it's not about to happen in the moment. By instructing the jury that imminent means immediate, the district court telegraphed to the jury that holding a loaded gun to a person's head and threatening harm does not qualify as an imminent threat. Well, that's not at all what the trial court said. The trial court said nothing like that. So here we have this appellate court. That's why they use the word telegraphed, because they can't say the trial court said that to the jury. The trial court didn't say anything like that to the jury. And she did not defend herself while there was a gun pointed to her head. Regardless. So the appellate court's being very, very misleading here. We therefore conclude that the trial court misstated the law by making a blunt instruction to the jury that imminent means immediate. And they go on to say the district court's error was not harmless. Well, if you believe it was error, it was definitely not harmless, because the narrow definition, what this court says is the wrong definition of imminence, basically requires that the defendant be found guilty by the jury, because there was no traditionally imminent threat at the moment she fired the fatal shots into her abuser. She asserts that what they're now saying is the wrong definition of imminence prejudiced her, prevented the jury from weighing her significant history of domestic abuse, blah, 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 blah. And we agree that a more nuanced definition is appropriate and will turn on the unique facts of each case. The defendant who asserts a self-defense claim must also show that the use of force was reasonable. Additionally, the degree of force used in self-defense must not exceed what is deemed necessary to a reasonable person. It's the duty of the fact finder, that would be the jury in a jury trial or the judge in a bench trial. It's the duty of the fact finder to make this reasonableness determination. Here, Clark testified about her abuser's violent behavior. The jury, if properly instructed, may have determined that Clark's use of force was reasonable in light of the circumstances. However, the district court's supplemental instruction, which was given at a critical stage of jury deliberations, placed a thumb on the scale for the prosecution. Actually, it was just the standard law in Minnesota. That was helpful to the prosecution because the prosecution's narrative was consistent with the existing law in Minnesota. The defense was not. We therefore determined that the trial court's supplemental jury instruction was both erroneous and was not harmless beyond a reasonable doubt. Accordingly, we reverse Clark's conviction. And she had raised two other issues on appeal, but once they reversed on this one, they don't need to consider the other one, so they don't. All right, folks, so that's where we are with that. Whoops. Now, of course, if who wouldn't be sympathetic with someone who's a victim of domestic abuse, right? That's perfectly normal. It's what we should, arguably what we should all have. The trouble is we often don't know, really, if the domestic abuse was genuine or not. And we are expanding the circumstances in which deadly force is deemed to be lawful. I mean, the human being's been killed, right? And in many of these domestic abuse killing cases where this spousal abuse syndrome stuff comes up, these arguments are made, are situations in which the person killed is literally in the moment. Zero threat. Sometimes he's asleep in bed and gasoline is poured over him and he's lit on fire and burned to death. That was the old Farrah Fawcett movie, right? The flaming, what did they call it? The Flaming Bed was that movie where she killed her purported abuser in that fashion. So by expanding the definition of imminence like that, we're basically saying that someone can be murdered for the crime of spousal abuse. Now, whether you consider that a morally offensive expansion of the privilege to use deadly force, I guess will vary by person. But that's what we're doing. The Burning Bed, that was the movie. Thanks. But that's what we're doing. Every time we expand the definition of the privilege to use deadly force against another person, we're increasing the scenarios in which a human being can be killed and have it not be deemed a crime. And that's what we're doing here. So someone could be, obviously who wants to defend a domestic abuser, right? Nobody wants to do that. But is the penalty for domestic abuse death? That's why normally we would apply the narrow definition of imminence and say whatever that person's done, if they're not presenting an immediate threat, you don't have a privilege to use deadly force on them. You don't have a privilege to take their life. But in this context, because of the sympathies that flow around a domestic abuse victim, every state really has, in some manner, expanded the definition of imminence in this way in the context of domestic abuse. Of course, a danger is then when women kill people out of anger. It happens, genuine murders. And then they speak with their lawyer and their lawyer says, well, if there's a history of abuse, you sure you don't remember any abuse? Because if there were abuse, we'd get a much more relaxed standard to justify your killing. And suddenly the woman remembers a bunch of abuse. And of course, in many cases, there's zero documentation. There's zero evidence of this purported abuse other than the woman's own self-serving statements. It's problematic, arguably. All right, folks. So that's where we are with that. Because today is the last day for the discount on our upcoming seminar, I'm going to pop it up again. This is Saturday, April 15th, about 2 weeks away from tomorrow, I guess. Saturday, April 15th is our full day law self-defense advanced class taught live by me, streamed to you at your computer, full day together, where you learn how to be hard to convict if you're ever compelled to use force in defense of yourself, your family, your property. And if you sign up for this class, today is the last day to get this discount, 10% off your registration. Tomorrow, effective tomorrow, it's the full price, folks. The discount goes away. I know many of you in the comments have taken this course, so if you'd like to say nice things about it, that would always be appreciated. And that's at lawofselfdefense.com/advanced. And now I'll take a look at super chats and questions. I'll go to the member dashboard first. Yes, so the defendant here was Stephanie Lewis Clark. I'll upload the decision and put a link to the decision in the description for today's show. Okay, on all the platforms. So give me a few minutes after we end the show, and I'll so you can read the decision for yourself. I always encourage folks to read decisions, especially this one. It's pretty much plain English. There's not a lot of legalese in it, because again, these appellate court decisions are really where the legal rubber hits the road in terms of defining what the law is in practice, in application. Let's see. Law self-defense member Sprout Point. Oh, he's got a little icon there. I didn't know you could do that. Question: what are the most common mistakes you've seen when a victim fails to see the imminence? Maybe hoping things will change and/or freezing would be the cause. Well, the errors go both directions, folks. People use force too early. They use force before the threat that's scaring them, before it's an imminent threat, one that can be immediately brought to bear. And it's because they're scared. And when you're scared and you have a gun, you tend to go to the gun under circumstances in which arguably the threat was real, but still in the future. It wasn't yet imminent. Or they use force too late is also very common. So they get scared, they go to the gun comes out, the other party sees the gun, starts running away, and then the defender's brain catches up and they fire a shot and hit the person in the back of the head as they're running away. and no longer an imminent threat. Were they an imminent threat? Did they threaten you with a knife? Yes. Are they still an imminent threat at the point you shoot them? Well, maybe not. Maybe the window of imminence is closed. And it can be a close call, right? There is a reaction time that needs to be taken into consideration, because you make the decision to present the gun and shoot when the threat is imminent. It takes, 0.2 of a second for your brain to recognize circumstances have changed, and 0.2 of a second to send a different, motor instruction to your hand. So there is an allowance. I mean, if someone spins around real quick and the bullet happens to hit them in the back, what controls is when you made the decision to fire. But if they've run half a block away and then your brain catches up and you shoot them, then the argument would be that a reasonable person would not still have perceived that as a deadly force threat. The window of imminence is closed. You're missing the element of imminence. You don't have self-defense. Again, folks, you can get this 5 elements of self-defense cheat sheet for free. We make it available for free. lawofselfdefense.com/elements. It's just a PDF download. So Law of Self-Defense Miles Dog says, question, contrast civilian versus cop use of force, rules of engagement, the 5 elements. I could spend an hour doing that, so I can't really do it comprehensively. The truth is the 5 elements apply to the police just like they apply to us. So it's really the same in terms of self-defense, legal justification for the use of deadly force in particular. So from that perspective, it's the same 5 elements, but they tend to have a different flavor, a different context. So I say when I talk about the element of imminence, that means you can't have been the initial aggressor. If you're the initial aggressor in the fight as a civilian, you've lost the element of innocence, you've lost self-defense. But really properly, I should say, you can have been the unlawful initial aggressor of force. And for a civilian, you really don't have a legal privilege to be the initial aggressor. So I usually don't use the word unlawful because most of us are not cops, and anytime you're the initial aggressor, you'd lose innocence and lose self-defense. But of course, police officers do have a legal privilege to be the initiator of force, right? They have to make an arrest with a non-compliant suspect. They're allowed to use force to compel compliance with the arrest. And it may be the cop who's the initiator of force there, but he's not the unlawful initiator of force. His initiation of force is lawful as part of his duties as a police officer. Now, if he goes too far, if you're jaywalking and he decides he's going to shoot you and he draws a service pistol, that would not be a lawful initiation of force. He's using deadly force under circumstances where it's not warranted. So police can lose the element of innocence too, but they don't lose it simply because they were the first to use force. They would have had to have been the first to use unlawful force. And there's a lot of non-deadly force that cops use routinely and it's lawful. So they wouldn't lose innocence as a result. That's just one example. Next time, if you ask the question when I'm covering an actual police use of force case, there may be more concrete details I could dig into to flesh that out for you. Let's see. I'm not sure why they don't name the abuse, the purported abuser, the victim here, why they only name them by initials. It's sometimes courts do that. Usually when they use initials, it's because the person's a minor. They're not an adult. But that would seem unlikely here. But maybe not. I don't know. Let's see. Law of Self-Defense member Floyd. Question, is there a mechanism for the state Supreme Court to periodically proactively review jury instructions so there is increased appellate clarity? Yeah, so they do that, but it's not frequent. So it might be once a decade. I mean, individual jury instructions can be changed at the Supreme Court's discretion. Florida does this all the time, I know for sure. But in any state, the Supreme Court, because there could be the state Supreme Court could change the law, right? They create new case law. Now the law is different. So now that whatever jury instruction would cover that area of the law, it needs to be updated to reflect the new legal principle that's just been espoused by the state Supreme Court. So that kind of ad hoc updating can happen. Maybe once a decade, once every 15 years, the general consensus on law may have evolved over time. And the state Supreme Court might say, there's a lot of other states doing things differently now, and maybe the consensus around that area of law has changed enough that we should impanel another collection of experts, judges, prominent lawyers, law professors, again, to review our jury instructions in their entirety, or at least in that area of the law. That happens from time to time. Let's see. All right, let's get to the super chats now. That was all the member questions. I will circle back before I close out to look at the member questions again. Let's see. Where is it? Supers. Here we go. All right. Adam Nash, $5 super chat. Thank you very much, Adam. Says, this sounds eerily similar to Commonwealth v. Schaefer. Yeah, Schaefer was a Massachusetts Supreme Court decision that basically did away with castle doctrine in Massachusetts when the other party was a co-dweller in the house. So that was also an abuse case. A woman was being abused by her spouse. She fled into the basement and armed herself with a .22 rifle. Her husband threatened to kill her. Came walking down the stairs into the basement. She shot him and killed him. And she was convicted, and she appealed her conviction and got all the way up to the Massachusetts State Supreme Court, and they affirmed her conviction, saying, well, there was a door out of the basement. She could have escaped from the basement. She had a means of escape as an alternative to committing a killing. And Massachusetts is a duty to retreat state, and they ruled that you have a duty to retreat even if you're in your own home, as if that's an alternative, a safe alternative to killing someone. This actually outraged the Massachusetts legislature enough that they enacted a castle doctrine statute. And Massachusetts really doesn't have any self-defense statutes at all. All the self-defense law in Massachusetts is case law, is court decisions, except for this castle doctrine statute. But then what happened? What do you think that the Massachusetts Supreme Court is going to do with a statute that overruled their decision? They don't like that statute. So every time they have the opportunity, they interpret that statute in a more narrow way, to the point where today in Massachusetts, because of the case law that's evolved after the castle doctrine statute was passed, you once again do not have a castle doctrine privilege in Massachusetts if the person you're defending yourself against is a co-dweller in the house. So we're back where Schaefer started. Okay, another super chat. Cycle Boy, $5. Thank you so much. Imminence, hypothetical. I'm stuck in place. I fell. The person says they're getting a gun, and if you aren't gone, they'll unalive you. Do you shoot them as they go to the car? Thoughts? Yeah, I mean, if you have reason, this is not stated in your hypothetical, but if the gun's immediately available, they're going to access it imminently, then the deadly threat is an imminent deadly force threat. And I wouldn't have any hesitation in shooting them under those circumstances. If their home is 10 miles away and they have to go home and get a gun and come back, then it's not an imminent deadly force threat in the moment, right? When they come back with the gun, then they may well be an imminent threat. So it's the question is, they don't have to be shooting you instantly, but the threat has to be immediately about to occur, so that there's no option to call for help or in a duty to retreat state to retreat from the fight. That kind of thing. And if they're, they got a gun in their belt, or they got a gun in a bag, or they got a gun in their car immediately adjacent to the scene of this fight, sure, they're immediately about to access that weapon. It's like, you don't have to wait for the muzzle to be pointed at you, right? Someone's got a gun in a holster. They say they're going to shoot you to death, and they reach for the gun in their holster. That's an imminent deadly force threat. Megan K, $10 super chat. Thank you very much, Megan. If this woman had been a platinum member of Law Self-Defense, would Law Self-Defense have given her the best legal defense, regardless of whether it was justified? Yes. I mean, her primary legal defense, of course, is her lead counsel, but we would have provided our consult to their lead counsel at no cost. In fact, Law Self-Defense platinum members are the only people these days who get our legal consults. We don't take outside consults anymore. But as a platinum member, we would have provided our usual robust legal consult on use of force law to her case. By the way, we would do that even if we thought she was guilty. It's just that then our consult would reflect our opinion that it was not a strong self-defense case. So that's not, I mean, obviously that's not what a client wants, but at least it would inform her defense attorney about what the reality of their self-defense argument was. We have cases where we get consults and I have to present my expert report, my expert legal analysis to the lead counsel, and self-defense. He thought self-defense, that's what they were going to do. We're going to trial, self-defense. And then when they got my report and they saw all the vulnerabilities, they were like, we better take that plea. And the plea was the smart play because self-defense would have failed. So at least it informs them about what the best path is for the client. And sometimes the plea is the best path. But sure, of course, I don't care what the underlying facts or law of the case are per se. I don't particularly care about the client per se. My job is to do legal analysis. That's all, to better inform, make the defense more capable. Okay, and let me see if there's any Rumble rants. It looks like not. So back to self-defense, law self-defense members. Looks like we're all good there. I'll do a little refresh here on the super chats. And it looks like we're all good there. So, folks, it looks like we got through another law of self-defense show. Last day of March. Tomorrow we start. Well, maybe not tomorrow. I have some other stuff I have to do tomorrow, but certainly by Monday, we're going to start with our April series of law of self-defense classes, shows, and it should be a pretty good one because I don't typically cover gun law. I do use of force law. Those are two different things. Like, when are you privileged to use force, not what kind of guns can you own, where can you carry them, and so forth, because gun law varies too much from state to state. But of course, in a deadly force context, a gun is your best means of lawful self-defense against a deadly force attack for pretty much everybody, right? The great equalizer. And we have a bunch of interesting use of force law and gun law stuff percolating through a whole bunch of states, like right now. Either the legislation is moving forward and looks favorable, or it's about to be signed, or it was just signed by a governor, or in the case of North Carolina, the governor's veto was overridden. And these are states in Florida, Idaho, Missouri, North Carolina, North Dakota, Oklahoma. A lot of interesting legislation, laws being pushed forward or being made into law. And they touch upon issues that are common across the 50 states. So if you didn't hear your state there, you'll still learn a lot from our discussion of those changes in use of force law and self-defense law. By the way, without exception, extremely favorable to the defender. Of course, the opposite is happening here in my home state of Colorado. They're passing a whole bunch of new gun control laws. So there's always that, unfortunately. All right, folks, until next time, please remember, if you carry a gun, so you're hard to kill, that's why I carry a gun, so I'm hard to kill. You owe it to yourself and your family to make sure you also know the law, so you're hard to convict. Until we meet again, I remain Attorney Andrew Branca for Law of Self-Defense. Stay safe.